Welcome, I am the Loud Little Ducky. Today we are going to be going over Laura Owens and her newest attorney, David Gringas. He likes to blog in the middle of ongoing cases. So we are going to get a peek into what his wee little brain has to say. So let's buckle up. His first post is on April 3rd, 2024. Testing, is this thing on? Hello? It says, I haven't blogged in way too long, but I can't handle the tiny character count on Twitter. Need more space to talk about complicated stuff. Let me see if I can remember how to do this. And then the cute little peppers. That is cute peppers. We may not have to like this guy, but we can love the peppers. And then here are some of his blog posts that we are going to go over. Some comments on today's Bachelor news. What just happened? Bachelor update number 2. Those were posted on the 3rd. Let's clear a few things up. The Bachelor update was on April 4th, 2024, as well as clear more things up part 2. He did a post about his guest appearance on The Bachelor. I mean, Dr. Phil. But we are not going to go over that because it really doesn't pertain to this case. If you want to go and find it, you can. I'm pretty sure Megan Fox and Legal Vices, they showed parts of it, but Dr. Phil is very big on copyrights, and he doesn't allow anybody to show his stuff because he wants all the money and nobody to take any of the money that might be his. He's greedy like that. So, blog post. Some comments on today's Bachelor news, April 3rd, 2024. David Gringas. Okay, phew. No more 140 character Twitter limits. Not gonna lie, trying to explain complicated legal issues in such a limited format was getting tedious. No mas. Let the word salad start spinning. Yes, you have a lot of word salad. A bunch of stuff that makes absolutely no sense. So he says, to begin, I want to clear up a few things. First, I've seen some people questioning my professional qualifications and implying that I'm some kind of fly-by-night, low-rent Saul Goodman. Har har, kids. If you knew what I knew, you'd punch yourselves in the face for being such idiots. Let's get that out of the way right up front. Okay, real mature. You sound real professional here, and you're trying to convince us you're professional? I don't think it's working. I graduated law school, University of San Francisco, in May of 2000. I took and passed the California bar exam first try. Then I moved to Arizona and took and passed the Arizona bar exam first try. Well, good for you. Why don't you give yourself a little pat on the back and a little hug to yourself? Because nobody gives a shit. At the start of my legal career as a young lawyer, I worked for a small 5-lawyer firm in Tempe. 2 lawyers in that firm handled nothing but family law cases. So I got to do tons of stuff like divorce, hell, child custody, nightmare, child support collection, cha-ching, all that crap. Who talks like this? I got to do all the crap things that a lawyer gets to do. Have some respect. But then he goes on to say, I have respect for family law attorneys, but it's not really my thing. Seeing people to go through a divorce, always accusing each other of some terrible shit, never thinking about the kids, it's not fun. You're not thinking about the kids, you're thinking of the money. That's all you care about. Self-image and money. Because you are an egotistical maniac. In the mid-2000s, I moved to a larger firm in Phoenix, about 35 lawyers. Still did some family law, including trials, etc. One day, I saw a lawsuit on my boss's desk with the name Colin Farrell listed on it as the plaintiff. Is that the Colin Farrell, the actor? I asked. Got a name drop. to prove that you're a big deal. If you have to say the thing, you're most likely not the thing. Keep that in mind. Yep, replied my boss. He made a sex tape with a Playboy bunny, and he is suing to keep it out of the public eye. Well, I'm sure he appreciates you putting it in the public eye. Okay, screw family law. That is the kind of case I wanted to work on. So I jumped on board, went to work like crazy, and learned the ropes of big-time litigation. I eventually got to meet Colin Farrell when we took his deposition in New York on Easter Sunday, 2005. We eventually settled that case, and I got to have lunch with the guy. Way nicer than you expect. If anyone cares, this was part of the legal proceeding. It moved from state to federal court and was eventually settled. So here he's just saying, we did this on Easter Sunday. I worked on Easter Sunday. Because we know he's going to throw shade later about Easter Sunday. This started my career in what I call internet law. What this means is the most of the time I handle cases involving people getting sued over something posted online. This frequently involves defamation claims, but it can also be stuff like copyright infringement, trademark infringement, or any other claims arising from content posted online. I sometimes handle other stuff, suing people for money, etc., but most of my time is spent on internet law cases. Because he wants to be infamous. He wants to be famous and with the famous people. Over the years, I have handled hundreds and hundreds of internet law cases. From 2009 to 2014, I litigated a crazy matter involving a Cincinnati Bengals cheerleader that almost went to the U.S. Supreme Court. Almost doesn't count, except for in horseshoes and hand grenades. I handled 2 jury trials in that one, and eventually we won 100% victory on appeal. This was and still is regarded as one of the most important internet law cases in the last 20 years. If you really want to read about this case, here's the appeal that I won, and here's an article about the story. Interesting, because if it's the biggest and most important internet law case that has been around in 20 years, how many of us knew about this before he mentioned it here? If you knew about it, let me know in the comments. I've handled a ton of other high-profile matters back in 2015. I defended a lawsuit brought by the king of Instagram, Dan Blitzerin. More on that case here. Total douchebag. Takes one to know one, I guess. And who is Dan Blitzerin? Is he a content creator? Was he the owner, CEO, founder, person of Instagram before Zuckerberg took over? Who is he? Because I don't know who he is either. My head must be in the clouds somewhere because I don't know anybody he's talking about. I mean, I know who Colin Farrell is, but I didn't know about his case either. In 2016, I was hired by none other than fucking Johnny Depp as a part of his breakup with Amber Heard. Okay. Why do you gotta refer to him as that? Because that's a big effing deal. That's a big name. His case just happened. And remember, I know Johnny Depp. No, you don't. I wasn't involved directly in the divorce. Yeah, backpedaling. And I did not directly represent Johnny. Instead, Amber Heard sued Johnny Depp's best friend here in Arizona over this article slamming Amber. Notice how that article is still online? Yep, because I kicked the shit out of Amber's lawyer in court, and she dropped the case about 2 days after she filed it. If somebody filed a case and dropped it, where did you kick the shit out of anybody in court? I don't think you did. And who talks like this? I can give you more examples, but you get my point. If you think I'm not a lawyer to take seriously, you will quickly learn otherwise. And yeah, my style is a little harsh, but I do try to treat people with respect until they no longer deserve it. I haven't seen you treat anybody with respect. You're one of those people that are like, I'm not going to give respect until you show me you deserve it, instead of starting out with being respectful and kind. You're automatically a jerk. And everything that we've learned in the last few weeks, we are not quickly learning that you are a lawyer to take seriously. You are a joke because you can't be taken seriously at all. So he says, now, enough about me. Yeah, we know that's your favorite topic, is yourself. Let's talk about this crazy Clayton Jane Doe case. And by the way, I have absolutely no idea why people think they aren't allowed to say her name. Say it. Her name is Laura Owens. There is no court order restricting the publication of her name. And it is not illegal for you to talk about her. Looking at you, Dave Neal. Dave Neal has many reasons for not saying her name. One, he probably doesn't like the taste of her name in his mouth. Two, she was going around threatening to sue and doing all this crazy stuff for anybody saying her name because she was anonymous. She didn't want her name out there. So maybe talk to your client and ask why people have to refer to her as Jane Doe, or did at one point. Oh, and for some of you special ed folks out there, no, there is no court order limiting Laura's right to publish her own medical records. Seriously, try to have at least a third grade level of comprehension on how the legal system works before you start claiming to be an expert. You look stupid. Stop. The only one that looks stupid here, David, Gringas, is you. Because if you looked at one of the last court orders that was put in prior to you coming on the case, you would see that the judge said, do not publish medical records and things like that into the public. Neither one of them. And Laura has published whatever she claims to be medical records that aren't actual medical records into the public. And then she tries to blame Clayton for it. So maybe you should go back to third grade and comprehend on how the court documents work, how the judge's rulings work. Because it doesn't seem like you have a full grasp on this case. You look stupid. Stop, as you would say. Now, as for the case itself, this is where I am going to be more careful. It is not appropriate to try a case like this in public. But here you are, typing away. I can't share every fact in detail with you because the rules don't allow that, and it wouldn't be fair to Clayton. We'll see what we think is fair to Clayton, because nothing so far has been fair to Clayton. Your client has gotten away with too much, and it will come to an end. And all she had to do was not lie. Own up to her shit. Yes, I know Laura already went public with way too much information. And yes, I know Clayton tried to punch back with his own press release. They were both dumb to do that. Or at least it's not what I would recommend. I hope you are telling your client that she's dumb. And I hope Laura sees your blog post where you throw your client under the bus. Like, that's usually not what you're supposed to be doing. Like, I would be really pissed if I had an attorney and they were out here just yapping their mouths with a bunch of stuff. Like, you're here to represent me. Focus on my case. Don't focus on what's going on out there. And definitely don't call me dumb. Also, yes, I am not fully up to speed on everything. Stop reminding me of that. I know it. I'm working on it. Give me an effing chance, guys. It's barely been a week. And this is not my only case. Having said that, a lot has happened in this case over the last 8 days since I got involved. I'm going to post a few comments about this moving forward, but only because I actually want you guys to be informed so you can speak intelligently about this stuff. We need you to get informed because you're not informed. And you know what you could be doing instead of writing these blog posts? Reading, looking at the case, watching videos and court hearings that your client was in, so you're fully up to date. Maybe zip your lips and open your eyes. I don't care, not even in the slightest, whether you love Clayton or hate Laura or indifferent. Everyone is entitled to their own opinions. Don't care which side you're on. You should care about the side of justice, about what is fair and the truth. But you don't. You seem to like to represent the scummiest of the scummiest people from things that I've seen that you've represented. Not everybody you've represented is scummy, but there are quite a few that are. What I do care about is that you have an accurate understanding of the facts. And if possible, I want you guys to understand how the law works. Because Jesus effing Christ, this group needs some serious help in that department. I don't mean that disrespectfully. You most certainly do mean that disrespectfully. Because you just used Jesus effing Christ. That's very disrespectful. So how are you going to say that? And some of us know how the law works. Some of us know quite a bit. Just because we don't have those degrees doesn't mean that we can't grasp the concept of court and law and looking at evidence and the whole entire picture. We have been waiting since the beginning for something to come out that says, okay, we can understand why Owens filed this case, why she did what she did. But so far, nothing has. And if when the trial comes around and something does, we'll be like, okay, you know what? We can see her point on that. Because while we may not like a person, we think what they've done is despicable, we do give credit where credit is due. But she has 0 credits right now. He goes on to say, before I was a lawyer, I worked at effing Taco Bell. He must like the word effing because he uses it quite a bit. I worked at effing Taco Bell for Pete's sake. And I, too, didn't know a freaking thing about this complicated, messy system. It can be complicated sometimes, and it can get messy. People are what make it messy. But the law is pretty black and white. There are some loopholes, and you can do things on technicalities and things like that. But I don't think it's that hard to grasp. I think if it's broken down in a way that people can understand, like a lot of lawyers and stuff on YouTube have done, and they've taken the time to help us learn and show us through examples and things like that, That's how a lot of us have come to understand more about the law than we already knew. And we appreciate it more. We're not going to appreciate something coming from a jerk and calling us stupid. It takes time, so please try and realize that maybe you don't know everything, and maybe you should ask questions before rushing to a conclusion. You just may learn something. We didn't rush to a conclusion. We've been waiting to see the evidence, waiting to see the proof. And so far, there is no proof, and everything keeps coming back that there is no proof of babies. There's no rushing. We have been waiting and waiting and waiting, and so has Clayton. And there has been nothing. So maybe once you realize what you're into right now, you might just learn something and realize that you don't know anything about this complicated, messy situation. This post is already too long, so let's leave it there for now. We can talk again soon. I will update when and if necessary. Not because I want to earn big bucks. This is not monetized, and I'm not charging Laura for writing this. Well, that would be unethical if you were. Because this has nothing to do with her case. You are not PR, and if you're bad at PR. And just because people talk about the case and give updates in a case, that doesn't mean that they're trying to earn big bucks. Some people believe in justice and pointing out wrongdoings and teaching people that this is not a situation somebody should be in. Look for the warning signs. These are things that you can do to get proof. And not let people run all over you or try to ruin your life without a fight. You say this is purely a public service message. I'm giving you a public service message. But continue on with your ramblings. Until then, please stick to some basic ground rules. Ask any questions you want, but be nice and respectful. I am getting too old to tolerate pricks, so don't be a prick, and I will do my best to reciprocate. Pricks and people acting in bad faith will get blocked. All others are welcome to talk. More to come soon. DSG. You are a prick. I don't know how you tolerate yourself. People acting in bad faith? Then your client needs to get blocked because she has acted in bad faith. Knowing she wasn't pregnant and somebody didn't want to be with her, she was like, fine, I'll ruin this person's life. I'll do this because I'm a girl. And you have to believe women, because women never lie, right? Wrong. You need to take a good, long, hard look at yourself in the mirror. Have your client stand there too. And ask yourselves what you actually are. What are you doing? Because this is not okay. Next blog post, also on April 3rd, 2024, David Gringas. What just happened? Bachelor update number 2. Hello, and a warm welcome to all 3 people who follow this page. Peace be with you. I moved off of Twitter, F you Elon, and my first non-X-itter post wasn't really about Clayton Echard case. I promised I would say more when I could, so let's do that. Well then, who was your post about? 'Cause you called Clayton and Owens dumb. So, okay. I mean, I guess it was a post about you too, your humble brags. A lot happened today, so let me explain. Earlier today, Clayton's lawyer filed a motion asking to withdraw a motion for sanctions he filed on January 3rd, 2024. Here's what he filed. We will be looking at that in the next video. I do have that. Okay, what does that mean? How does it affect the case? Does that mean Clayton lost? What's going on? And before he explains these things, because he thinks we're all dumb, what does it mean? It means he wants to withdraw his motions for sanctions. It's right there in the title. How does it affect the case? It just means that right now he's not asking for sanctions. Does that mean Clayton lost? No, because that wasn't a motion for Clayton. It's actually a win for Owens right now. But maybe it won't be later. What's going on? True answer, it actually doesn't matter that much, but let me explain. The timeline of this is important, so let's recap. My client, Laura, filed this paternity case on August 1st, 2023. Clayton filed what is known as a response. Yeah, usually that's what it is. When you respond back to something, it's a response. But I'm glad you broke that down Barney style, because none of us plebs could understand that. On August 21st, 2023, his response basically said, "No, I'm not the dad. Let's get a test and confirm I'm not the dad, and then this will go away." This is standard stuff. Nothing is standard in this case because of your client. It should have been that simple. In late September or early October 2023, Laura and Clayton submitted samples for early testing. Those samples came back inconclusive. Lie, right there. They did not come back inconclusive. The two tests came back little to no fetal DNA. That's not inconclusive. They weren't like, oh, it was too diluted, it was a bad sample, we didn't have enough, the blood clotted, we weren't able to test it. None of that happened with the two samples that came back. And then one is lost somewhere in transit. Laura claims she had bleeding in mid-November 2023, and she went to an OBGYN for care. They confirmed the pregnancy ended around that time. Yes, Clayton says this whole thing was a sham, but that's another issue. She didn't go to an OBGYN for care and learn about her miscarrying and bleeding. Because when she had a telehealth visit, that's what she did when she started bleeding and supposedly miscarrying. And that telehealth doctor told her, oh, don't worry about it. You don't need to go to the hospital, nothing. That's ridiculous. That's a lie. So she didn't go to the OBGYN. She went to somebody, Dr. Higley, I think, at the end of October, beginning of November. And she thought she was 100% sure she was still pregnant, 23, 24 weeks pregnant. So, no, she didn't know that. Once again, you don't understand the timeline. Do more research on your own case. Okay, cool. We all know that timeline. Let's move on. Yeah, we know that timeline, but that timeline is false, per your client's own words. The next thing that happened was in early December of 2023, court administration said they would dismiss the case for lack of prosecution. That is normal. It happens in any case where the case appears to be inactive. Court administration will just drop the case, although it can be refiled later, maybe. If Clayton had done nothing, the case would have been administratively dismissed. He could have called that a win and gone home, but he didn't. He couldn't call that a win because nothing was proved. That woman, Owens, could still go out there and say, I was pregnant with his babies and I miscarried, and he still wanted me to get an abortion, and he still didn't want me to have the kids, and he treated me like crap. That's not a win, because she's still getting away what she's been doing for 10 years. Clayton wants her to admit she was never pregnant. She lied. He doesn't even care why, because no reason is good enough to lie about this. Nothing justifies this. So it's not a win, and it's not about that for him. He's not looking at it as points and winning. He wants his life back that she has tried to destroy. But of course you would just look at it as wins and points, and that's it. You don't think things actually matter in people's lives. You don't care about lives that have been destroyed. In mid-December 2023, Clayton hired a lawyer to appear in the paternity case. That lawyer, Greg Woodnick, filed a bunch of things, basically asking the court to find that Laura lied and asking the court to say the whole case was BS. He pushed back hard. Fair enough, maybe. This is where it gets tricky. It was tricky before this point. Let's be clear on that. When Woodnick first appeared in the case, Laura did not have a lawyer. Wisely, she quickly hired a lawyer, and on December 28, 2023, that lawyer filed a motion telling the court Laura was no longer pregnant and the case should be dismissed as moot. Makes sense? No, it doesn't. No, it does not. In fairness to Clayton, the motion to dismiss filed by Laura's first lawyer was technically wrong. Although the miscarriage mooted most of the case, Clayton did ask for sanctions in his response, and that the issue was not moot despite the miscarriage. Based on this, I agree, as the court later ruled the whole thing could not be dismissed as moot. This isn't a huge deal, it just means that even if Laura was no longer pregnant, Clayton still had a score to settle. I agree, that's not a problem. His position was fair. Also, he's not trying to settle a score, or score to settle, or whatever you want to say. He wants this woman to admit to lying. And why this case isn't moot. She filed for paternity. What has not been established is paternity. Also, that she was pregnant. That has not been established either. So this case has not figured out the two things that this case was about. So it's not moot. Throw the sanctions in there because she can't help herself from lying and disobeying court rules. Yeah, just keep adding on. It's only going to be bad for her in the end. Here's the problem. Here's where the problem happened. After Laura's lawyer moved to dismiss on December 28, 2023, on January 3, 2024, Clayton's lawyer, Woodnick, filed a very specific type of motion for sanctions. This motion used something called Rule 26, which is basically a rule that says you can't file bullshit cases which have no basis. Yeah, you shouldn't be allowed to. Clayton said it was bullshit, and therefore he was entitled to Rule 26 sanctions. Has anybody proven Clayton wrong on that? Because so far it looks like it's bullshit, what she's trying to do. Gringas says, but Clayton's lawyer made a big mistake. Rule 26 has something called a safe harbor. I won't bore you with the details, but it works like this. Courts are busy and they are used to seeing everyone say the other party is lying, etc. This happens in most, if not all, cases. Yawn. Sir, this is not a script, a play. You don't need to put your actions in there. Like, exit stage left, please. You have to feel bad for court staff. How do they know who to believe? Rather than hearing every petty dispute over he said, she said, the courts have created this funky system where a party can ask for sanctions, meaning monetary penalties, if someone files a bullshit case. But there's a catch. You can't file the motion for sanctions unless you give a clear written warning first. The warning must be specific, and it must follow the letter of the rule, or you could say the law. And once you give that warning, the party who allegedly filed the bullshit case has a safe way out. They have an absolute right to drop the case within a fixed time period, currently 10 working days after the notice is given. If the bad guy takes the safe harbor, they get to drop the case, and they get immunity from sanctions for doing the right thing. This saves the court staff from having to deal with all the nasty disputes. It's a good thing, even if it means some people who filed bullshit cases get to walk away. No, that's not a good thing. This is where Clayton screwed up. He filed a motion for sanctions, but he forgot to give the 10-day written warning. Oops! You still think the team is rock solid, Dave Neal? Okay, well, we'll learn more about this later. But it seems like you've never made an oops in your life. Anyways, his lawyer just filed the motion without following the proper steps. A first-year law student can tell you what that mistake means. If you don't follow the rule, you cannot get sanctions. You are done. Literally 100,000 cases say this with no exception. In fact, if you file a motion for sanctions without following the rule, you open yourself up for getting sanctioned for filing a bullshit motion yourself. Well, you filed a bunch of bullshit motions already in this case, so maybe you should be fined and sanctioned. Just because we think a law team or a lawyer is doing a great job doesn't mean that we do not think that they haven't made mistakes or could have argued something better or should have inserted something else in there. Like, that doesn't mean that we think they're perfect. It just means that they're doing a damn good job. They're doing what they should be doing and being a zealous advocate for their client and ethically. That's not what your case and your side of this case does. Got all that? Yeah, we're not freaking 5. This is exactly what happened here. To fix this, I tried to talk to Clayton's lawyer, but he snubbed me. I understand why. When you make a mistake, it's hard to admit it. That's fair, and that's life, but it's bad behavior as a lawyer. We're supposed to be bigger and better than that. If you F up, the first thing you do is admit it, fix it, and apologize. Move on. Own it. When are you going to admit to the mistakes that you've made? Because you need to be bigger and better than that. Fix it, apologize, own it. Because if you don't, that's bad behavior as a lawyer. Don't you think, Gringas? And I have a hard time believing Woodnick snubbed you. Maybe you're a jerk and he didn't want to deal with you. Like you say, you don't have time for pricks. Maybe he doesn't have time for pricks. Because all the communications that we've seen with Laura's other attorneys Corey Keith. He never snubbed him. He was never just downright rude to him. They were on opposite sides, but they were respectful to one another. You know, Woodnick actually felt bad for their lawyers because of what they were getting into. So I have a hard time believing that he snubbed you, unless you were just being a dick right off the bat. After Clayton's lawyer refused to withdraw his bullshit sanctions motion, I did what the rules require. I gave him written notice that I was going to seek sanctions against him. I gave him a chance to fix this. He was entitled to the same safe harbor he forgot to give my client. Initially, he refused, but I explained to him that was incredibly dumb because it put him at risk of paying all of Laura's legal fees, $35,000 plus. There was no question he did not follow the rule. So there is no question his sanctions motion was fatally defective. So you called him dumb. Wonder why he snubbed you. He was going to lose, no question in my mind. I'm not sure what goes on in your mind is fully accurate. In addition to threatening to file my own sanctions motion, which would have been appropriate, I also drafted a separate motion that asked the judge to toss Clayton's sanction motion based on his failure to follow the rules. This is called a motion for judgment on the pleadings. Under our local requirements, I could not just run out and file that request. I had to talk to Clayton's lawyer about this, and I had to give him a fair chance to fix the problem before I took it to the judge. Well, good for you. I'm glad you did that. Because the judge would have told you to do it anyways. Said, why haven't y'all talked this out? You haven't even tried contacting him, talking to him? Y'all can go work this out. And then if you still can't do it, then we'll figure something else out. You would have gotten in trouble for the judge if you wouldn't have done this. I asked Clayton's lawyer to speak with me about this on Saturday, March 30th. No response was received. I asked again the next day, Easter Sunday. So here's the Easter part that he's going to rub in people's faces. Because in the past, he has worked on Easter. Again, no response. I finally sent an email today, April 3rd, 2024, telling Clayton's lawyer that if he did not respond, I was going to file my motion with the court, asking the court to rule that Clayton's sanction motion was defective as a matter of law. Clayton's lawyer did not respond to my email, so I called the guy, and he wouldn't take my call. I finally left a message saying if he wouldn't speak to me by 4 p.m., I was going to file a motion and tell the judge he was refusing to speak with me, as required by the rules. That would have looked really bad on his part. I don't know what Woodnick's religious beliefs are. But let's say he is Catholic or Presbyterian or something that goes really hard with like Lent and Easter and all of that stuff. Good Friday, all of that, the whole entire weekend. That's based on religion. And if Woodnick has a strong faith and goes to church and is really involved in that and with his family, that may be a no work day for him, no work weekend because of religious beliefs. And he has permission to do that. And his client doesn't have a problem with that. But the fact that you've got your panties in a wad over an Easter weekend is ridiculous. A few minutes later, I got an email saying Clayton's lawyer caved. He agreed to withdraw the motion for sanctions that he filed way back in January. This means that issue is off the table. Oops! Here's the withdrawal request Clayton's lawyer filed, and here's the draft motion I threatened to file if he didn't withdraw that pleading. That will be in the next video as well when we go over the filings. You can reach your own conclusions, but reading between the lines, I think what happened is obvious. Clayton's lawyer jumped the gun, filed a motion too soon, and did not comply with the rules, and he forced both sides to spend a lot of money battling over this issue. After I was hired, I went back and checked for any mistakes made by any of the lawyers, like I always do, and I immediately noticed this big one. To do my job as an advocate, I try to ask Clayton's lawyer to fix the problem by withdrawing his motion. And at first he refused to do the right thing. I pushed forward by drafting a motion asking the court to rule in our favor on this issue, and at the last minute, rather than defending his mistake, Clayton's lawyer caved and admitted defeat. He did not admit defeat. He doesn't necessarily need this motion. He's not admitting you're right, or that your threats worked, or he's scared of you. Because I can guarantee you he's not. And you talking about, oh, everybody else makes mistakes, I don't make mistakes, I'm perfect. Like, it's so ridiculous. You just act all high and mighty. Get off your horse, or get off Owens' horse. Because y'all both are like, y'all need to come back down to reality. This is not a bad thing. I actually have respect for Clayton's lawyer doing the right thing here. That is exactly what he should have done. And if he had refused, I would have called him to the carpet on that mistake. And he would have lost. Hard. Okay, you sound like a stupid teenager. He could have faced serious financial sanctions for failing to follow the rule. I'm glad he changed his mind. It was the right thing to do. Does that mean Clayton's lawyer is incompetent? No, absolutely not. Over the last 20 years, I have seen tons of lawyers make the same mistake. It typically happens when the lawyer gets too emotionally involved and they lose their objective professionalism. I'm not saying that's what happened here, and honestly, I don't care. I do care that Clayton's lawyer eventually followed what the rules required him to do, and give him credit for that choice. It was the right move. Hard to do, but I'm glad it happened. Once again, Gringas makes zero mistakes. Over the last 20 years, he says he's seen other lawyers make this mistake. But him, in the last 20 years, never has made mistakes. Oh, to think that you are so perfect. It's a shame. Does that end the case? No, absolutely not. Which is why I do not understand Clayton's initial refusal to withdraw this silly motion. There are like 3 to 4 other ways to ask for sanctions, and those other ways don't have the same strict requirements as the one rule cited in the now withdrawal sanctions motion. What this means is simple. Clayton is asking for sanctions against Laura, and if the court rules in his favor at trial, he can ask still for some, but probably not all, of his attorney fees to be paid by Laura. I have explained that to her, and she fully understands. I don't think she does. I don't think she understands any of this. So for now, onward we march. Absent a last-minute settlement, which is probably the most likely outcome, I don't see this thing settling. I'm glad he thinks he can get this to settle. But unless there is something in a settlement where Laura admits she was never pregnant and that she lied about this entire thing, I don't think there's going to be a settlement. Because this isn't about money. Sure, would he like her to pay his bills on the attorney fees because of this lie that she's done? Yeah. But for him, it's about showing that he is a good person. He is honest. He didn't lie in this. his image out there, what he stands for, so that people can know, okay, this is a guy we can trust. He has credibility. He's telling the truth. We will have a trial in June, and the judge will decide who is lying and who is telling the truth. The only issue not up for debate that day is the bullshit motion for sanctions that Clayton filed in the January, which he has now withdrawn. You have said that 20,000 times. And that is a good thing. DSG. Yeah, what's up for debate is your bullshit case that your client filed and how we all got here in the first place. That little silly little filing she did. Blog post 3. Let's clear a few things up. The Bachelor Update, April 4th, 2024, by David Gringas in Scottsdale. It's impossible to cover everything in a single post, so I want to take a minute to break something down about what is happening in the Owens v. Echard Bachelor case. As explained yesterday, Clayton Echard withdrew his motion for sanctions against Laura Owens. What does that mean? It just means Clayton has dropped the motion he filed back in January asking the court to punish Laura for lying about being pregnant. This is where you should learn to shut your mouth. Because if I was Owens, you saying, punishing me for lying about being pregnant, I would be pissed. Because right there, the way you worded that, makes it sound like she's just not going to get punished for lying about being pregnant. You imply that she lied about being pregnant, the way you've worded that. That may not be what you meant, but that's what it looks like. Maybe put filed back in January asking the court to punish her for what he thinks Laura is lying about. But Laura isn't. Like, put something in there. We're just like, punish her for lying about being pregnant. Okay. So she did lie about being pregnant? Is that what you're saying? Does this mean the case is over? No. Does this mean Laura didn't lie? No. Does this mean the court isn't going to punish somebody for lying? No. All those issues remain on the table for the judge to resolve. Why are you saying you're saying that your client might have lied? Like, this is not what you need to be putting out there. And they say to the jury, the attorney's words aren't evidence. But if your attorney is going out there saying all this stuff, I think it can be brought in, especially to a judge who can weigh that stuff. The only change in the case is that Laura claimed there was a technical problem with the original sanctions motion Clayton filed. Clayton's lawyer disputed this, but rather than fighting about it, not every dispute is worth fighting over, even when you're right. Yeah, because you're never wrong, right, Gringas? Clayton agreed to withdraw his original motion. He remains free to still ask for sanctions in other ways. Great. Can you please stop saying they dropped the motion for sanctions? You said it a million times earlier. We don't need you going back and saying it a million more times in this blog post, but thank you. Now, what's next? We have a very short trial, 2 hours set for June 10th. The issues for trial are very narrow. So let's try to get a grip on what is and what is not going to happen. I need you to get a grip, just in general. First, Laura started this case by filing a petition for court order for paternity. In legal terms, this is called establishment petition. Well, thank you. What that means is Laura was asking the court to make a finding that A, she was pregnant, B, Clayton was the father. Put differently, she wanted the court to establish Clayton was the father of her unborn child/children. And this is why I was saying that this case isn't moot. Even if she hasn't had the babies, or has had the babies, either way, because she wanted the thing to prove she was pregnant and that Clayton was the father of this pregnancy. None of those things have been proven. You have not proved she's pregnant. You have not proved that Clayton was the father. Therefore, it is not moot. As everyone knows, Clayton denies Laura was pregnant. He denies he was the father. He says he's never actually had sex with Laura. You need to wait and hear what he says about this on the stand under oath, because it may not be exactly what you were expecting. We know you have to have intercourse in order to make babies. So, if he mentions everything under the sun except for intercourse, it's not going to change our minds or be any different than what we were expecting. But okay. For her part, Laura will say she did have sex with Clayton, and after that happened, she tested positive for pregnancy at least 5 times. No, she did not. She tested positive for HCG tests on a pee stick, which can be pregnancy tests. But a pregnancy test, a pee stick, does not confirm you are pregnant 100%. It's just the starter to be like, hey, you might want to go to a doctor and confirm this, because it looks like you possibly are pregnant. That's all it is. It's an indicator. And for the record, Clayton has argued that a HPT, home pregnancy test, is somehow not proof that a woman is pregnant. It's not. It sounds like you haven't researched enough about this. What he probably means is that a home pregnancy test is not conclusive proof that a woman is pregnant. Yeah, it's not conclusive. And Owens has not done anything to get that conclusive proof that she was pregnant. She's just relying on pee sticks. And that's it. And to save him any surprise, Laura agrees 100%. It is absolutely possible to have false positives on a test. Okay, she's agreeing that there can be false positives on tests. Right. But how common is that? Consider this. According to the pregnancy kit manufacturers, most at-home pregnancy tests are 98% to 99% accurate when you use them, exactly as instructed. Positive results can be trusted, but you can get a false negative result if you take the test too soon. Blood tests tend to be the more expensive and inconvenient. They are. But if you are pregnant, you still have to have them. That's why you do the pee stick first, and then you go get blood tests to see where levels are and everything like that, to see if there's any issues in your lab work, and to for sure see where your HCG levels are. All the pregnancy test does is says, yes, you have HCG in your system. Doesn't tell you how much, and it doesn't tell you why. That's why you need the blood tests and sonograms and stuff. So yes, if Clayton argues that home pregnancy tests are not 100% accurate, we will get no pushback from Laura because that is true. The tests are only 98% to 99%, so if Laura took one test, there is a 1 or 2% chance she wasn't pregnant. Bear in mind, Laura took multiple home pregnancy tests and they all showed the same thing. That's great. Nobody is denying that Laura has HCG in her system. Nobody has said that. We obviously know somehow she has HCG in her pregnancy or in her body. What we don't know is why. What is giving these positive HCG tests, positive pregnancy tests? Is it a medication? Is she, because she's on a certain medication, not going to be able to rely on those and is going to have to go in to get blood tests to further confirm because a pee stick isn't going to be accurate for her because it's going to come back positive basically every time? Does she have a tumor? Maybe on her brain? Because, I mean, that could explain a whole lot. Like, there are things out there that can figure this out. Nobody has said they don't believe that she tested positive on a pregnancy test. They know she tested positive on a pregnancy test. We know that there's HCG, or there once was HCG on the pregnancy, or on the pee stick for the pregnancy test at home. We just need to know what is causing it. And she should know too. So that if and when she ever is really pregnant, Lord help that baby and the man that actually does get her pregnant, she knows what steps medically she needs to take. So, because she's not going to be able to rely on these home pregnancy tests because they're not giving her accurate information for one reason or another. And that's what Clayton wants. He wants the proof beyond a pregnancy pee test. Because it's not an absolute. It means nothing. It means there's a possibility you are pregnant. But you're a man, so maybe you won't understand this. No offense to any male listeners. It's just him thinking he knows everything. Mansplaining, that's what he's trying to do. For the record, there is no requirement that a woman obtain a 100% reliable pregnancy test before she files a paternity action. In fact, there is no requirement that the woman have any pregnancy test at all. The only requirement under Arizona law is that the woman must have some plausible basis to think she is pregnant. That could be something as simple as she had sex, missed a period, is experiencing symptoms of a pregnancy, weight gain, morning sickness, etc. So basically, while a positive pregnancy test is nice, it's absolutely, positively not a prerequisite to file a paternity action. You may be right there. But that's not where we're at in this case. We got to the point where she was 5.5 to 7 months pregnant. And she was claiming to still be pregnant. And she had a growing belly. So she kept lying. Well, what she could have done is, if she took a pregnancy test or thought she was pregnant and went to the doctor and everything else, because usually that's what you do when you think you're pregnant and you have the means and stuff to go to a doctor, you go. And then if she found out, hey, I'm sorry, you saw the test like I did, it said, that it was positive, but when I went to the doctor, they said that it was this, so I am going to withdraw the case. I'm sorry that I put you through this. There would have been nothing, but she ran to the media. She did all of this bullshit. And she continued to lie. So in the beginning, yeah, she could have filed that. But where she continued to lie and perjure herself and everything else, that's where things got messed up. In addition, it's important to note Laura's belief she was pregnant was not based solely on home pregnancy tests. She also had a blood test done, which is arguably more reliable. The test was also positive. Where is that blood test? Has anybody seen that blood test? Because I haven't. I'd like to see that. In this extremely odd situation, here's what I expect will happen at trial. Technically, Laura is still the petitioner, kind of like the plaintiff. That means we will go first at the trial. But every issue raised in Laura's petition is moot because she claims she had a miscarriage in November 2023. No, it's not. It's not moot. Because she has not proved she was pregnant, and she has not proved that Clayton was the father. Not moot. Thus, she is no longer pregnant, there is no baby or babies on the way, and thus there is no issue of paternity for the court to establish. That is all moot now, and the courts generally will not resolve moot issues. I don't think they're moot issues. So you might want to be prepared in case the court doesn't side with you. I plan to explain all this to the judge, and I will ask her to simply dismiss Laura's paternity petition as moot. That doesn't mean she loses it. It just means there is no remaining issue of paternity for the court to decide. We still need to decide if she was pregnant. We need that. That's important. Because one way or another, it's coming out. Maybe it goes to a different court case, and it's in a different civil, where he sues her for money and has to prove why he's not owed this money and dig everything up. Because this is coming out. Because I know Woodnick and Clayton and Greg Gillespie and Maraschini and many others are tired of the fact that this woman keeps doing this to people, and she has not had to pay any consequences. That is done with and over. She is going to have to own it, as you say. Admit, apologize, fix it, and move on. And not ever do this to another person. For his part, Clayton is not satisfied with his outcome. He wants more. He has asked the court to give him something called an order of judgment of non-paternity, sort of the inverse of establishing paternity. Exactly. Basically, he wants the court to say he is not the father, despite the issue being moot. And he wants the court to go even further by making a finding that Laura was never actually pregnant to begin with. Now you're getting it. That's what he wants. Make her admit it. This is one of the most misunderstood aspects of this case, so I want to make something very clear in this litigation. When a party takes a position or makes a claim, the person making the claim generally bears the burden of proof on that issue. What that means is if you claim something is true, you have to prove it's true with admissible evidence. If you fail to meet your burden of proof, the court will find against you on whatever issue you were trying to prove. Yeah. So where's your proof? In this case, Laura is no longer claiming to be pregnant, so that issue is moot. But she was at one point. So we need the proof that she was pregnant, and we need the proof of how she became not pregnant. Despite the claims to the contrary. However, she agrees it is impossible for the court to establish that Clayton was the father, because DNA tests conducted in the case were inconclusive, and there is no longer any fetus to test. They were not inconclusive. Little to no fetal DNA means there was no fetal DNA, or there was very little for it to come back. I could go get a DNA test done, and you know what it's going to show? Little to no fetal DNA. Because I am not pregnant. I do not have a fetus. They're not going to come back and say, well, we don't know if you have DNA for pregnancy. We don't know. Like, I could go get one and it would say the same thing. It's not inconclusive. This is why Laura asked to dismiss the case back in December 2023. No, the water was getting too hot. And she's like, oh shit. This is not what I expected to happen. This is not how any of the other cases happened. I'm going to get found out. I've got to get rid of these babies. Because they're all going to know that I'm a liar and I made all this up. That's what your client did. Let me explain why this matters. Arizona law provides a set of rules for how paternity can be established. This is normally done by DNA testing, and it is important to understand exactly what the law says about this. So let's look at it for yourself. Here is the full statute. A man is presumed to be the father of the child if he and the mother of the child were married at any time in the 10 months immediately preceding the birth, or the child is born within 10 months after the marriage is terminated by death, annulment, declaration of invalidity, or dissolution of marriage, or after the court enters a decree of legal separation. Genetic testing, number 2, genetic testing affirms at least a 95% probability of paternity, which we don't have because there was no fetus to have that. Number 3, a birth certificate is signed by the mother and father of a child born out of wedlock. Number 4, notarized or witness statement is signed by both parties or both parents acknowledging paternity, or separate, substantially similar. Notarized or witness statements are signed by both parents acknowledging paternity. See number 2 there? In most paternity cases, and yes, this is not my first one, the issue of paternity requires DNA testing to be performed, and the test results must come back showing a 95% probability match to the alleged father. If that happens, the court will issue an order finding paternity has been legally established. In our case, the DNA tests were inconclusive. This means they did not have enough tissue to give a meaningful result, which is different from saying the test affirmatively excluded Clayton as the father. Why there's not enough tissue is because there's no fetuses. Because if she had fetuses, there would be enough. This is why it proves she was not pregnant. Because Laura was the petitioner in this paternity case, and because she cannot show a DNA test with a 95% probability that Clayton was the father, the court is going to conclude that the paternity was not shown here. Also, We all know that, you know, earlier in a blog post, he said mid-November. Most of us know that he has come back later, which we'll look at in filings, that she was saying in July she miscarried. Which means when she took those DNA tests in September or October, there was no babies. So guess what? Little to no fetal DNA because she miscarried in July. Explain that one. It's not inconclusive. That just leaves Clayton's counterclaim, in which he asks for an affirmative finding that he was not the father. But remember, the party who makes the claim bears the burden of proving that claim. And since Arizona's paternity statutes generally require a very high degree of proof, it is unclear how Clayton plans to meet that burden at the trial. Yes, Clayton's testimony about all of this is still evidence, but by asking for the court for a specific factual finding in his favor, what Clayton is doing is similar to contesting paternity case in which he alleged father walks into court and tells the judge, "The mom claims I am the father of the child, but I deny this, and I want you to rule in my favor based solely on my word." Because of the issue on Clayton's paternity, his word and Laura's rebuttal is the only evidence the court is going to hear. No, it is not. Because if it was the only evidence that the judge was going to hear, she wouldn't have had Laura sign the HIPAA release. Try again. Go back to read your case. Nobody is asking anybody to take Clayton at his word. Clayton's not asking you to take him at his word. Does he want you to believe him? Yes. But he also wants you to look at the evidence. Look at everything. And tell him that he is the father, or that there were babies. Because nobody can do that. Not right now. Unless there's some magical evidence that nobody's seen yet. So the court is going to hear more. And I hope you have prepared yourself for the court hearing more. Because it's going to happen. No family law judge anywhere in the country would make a decision of non-paternity based solely on the father's denial. But that is what Clayton is seeking. No, it is not. And you're right. No judge is going to just be like, "Oh, because you said so. All right, good enough." No. Obviously not. We would side with nobody if it was a he said, she said. But there's other things that come into play. And Laura, opening her big mouth and lying constantly, makes it even better for Clayton to prove his case. Because she's kind of proving it for him. The point here is that given the unusual posture of this case, Laura's position is that if Clayton wants the court to find that Laura was never pregnant and or that Clayton was never the biological father, those are issues Clayton must prove. He bears the burden on both of those matters, and the standard of the evidence in court will likely apply is very high. It's called clear and convincing proof. Yeah, we've got pretty clear and convincing proof. Thanks to your client. And your client can use that in court against her. This is a civil case, but anything you say or do can and will be used against you. As I keep saying, everyone needs to wait for all the evidence to be presented in court. Once that happens, Laura is confident that there is no possible way that Clayton will be able to meet the high evidentiary burden for the claims he is making. If she is correct, this case will end with a judgment in favor of neither side. To me, that seems like an incredible waste of time and resources. But at least for now, that is where things are headed. I don't think so. I hope you have another map. 'Cause your map is outdated. And we still would like to see all the evidence. Because we have nothing right now. Nothing at all. Even in her deposition, she's screwed up, and we don't even know all the deposition. So we can't wait to see all the evidence. And if it proves that Laura is telling the truth somewhere, and that she's just done all this to make herself look bad, which seems kind of dumb, we'll be willing to admit it. If something proves that Clayton was lying, we won't be supporting Clayton if it's shown that Clayton is lying. But right now, that's not what the evidence shows. But we will be waiting and watching for Owens' evidence, because we're dying to see it. I didn't want to spend so much time on this today, but another issue came up that I think is important enough to share. He starts out in this next blog post that was also posted on April 4th, 2024, called Clearing More Things Up Part 2. He goes on to say, a common theme, in fact maybe the only theme in this case, is the idea that there is no medical records to show Owens was ever pregnant. Clayton's lawyer recently made the representation to me. At the time he did, I was not familiar enough with the case to understand what the facts showed. Now that I'm getting familiar, you're still not there yet. That's why you don't need to be blogging, you need to be in this case, because I'm sure it's pretty thick. There is something really important that needs to be said. First, the idea that there are no medical records to show Owens was ever pregnant is 100% categorically false. Yes, there are records, tons of records. Are they 100% perfect? Are they 100% conclusive? That is a mixed question of personal opinion. What would it take to make you believe you were pregnant? And it's ultimately something to judge. The judge, in our case, will have to consider. Good thing she's a woman. And if we had a man, what would it take for him to believe that his wife was pregnant? Because I'm sure he would be like, oh, it's a pee test, but if she didn't have ultrasounds, didn't have a growing belly, any of that, he might not believe her. He might be like, you think something's wrong? Because, we're almost to the due date, and your belly is still the same size as it was before you got pregnant. Like, you don't know any sonograms, you don't have any proof of a boy or a girl, or, updates, you haven't gotten any blood tests done. They don't have to be perfect. But what it takes is taking a pee test, then going to the doctor to have the doctor confirm it with an ultrasound and some lab work. That's what it took for my daughter and myself to convince people and ourselves that we were pregnant. Laura's position is clear. If you want to say you don't trust her, that's your opinion. If you want to say you don't find her medical records to be convincing, that's your opinion. No, it's not an opinion, it's a fact. Because a photo of an appointment that you never went to and a photo of a pea stick or peach stick results is not proof. But it is absolutely dead wrong for anyone to say that no records exist, because they do. Those are not medical records. I mean, if you want to call them medical records, you can, but there's nothing from doctors saying they've confirmed a pregnancy, confirmed ultrasounds, confirmed blood tests, confirmed a miscarriage, which it wouldn't be a miscarriage. Like, there's nothing that shows she saw any doctors. There is stuff that showed she lied about it. With Laura's express permission, I want to share one of those records with you. Oh, and before you go there, no, there's no court order stopping Laura from publishing her own records. We've explained this to you, Gringas. The judge said don't be spreading things out there, because Clayton can't go out there and spread these things. He would get in trouble. And Laura would go tattle on him. Or be like, oh, he's breaking a restraining order. He's not supposed to be publishing things. He's talking about me on Instagram. These two might be the perfect pair. Now, as you probably know, Laura took lots and lots of home pregnancy tests. She even took a test that Clayton bought and gave to her. All the tests were positive, and yes, Clayton believes all these tests were wrong. Although I don't know what medical expertise he has to express such an opinion, that is something the trial will explore. She didn't want him going to the ultrasound. She didn't tell him about it. Like, it would have been so easy to be like, look, does this look like I'm lying about it? You want to go to the doctor and see the babies in my stomach? Will that make it real to you? Because that's what I would have said. You don't believe me? Go to the doctor with me. I'll prove to you I'm not lying. But let's put that aside and assume every home pregnancy test is unreliable. What other evidence does Laura have? Before I answer that, let's look at what Clayton's lawyer told the court about this exact point on January 25th, 2024. Clayton's lawyer filed a brief, reply to petitioner's response for motion for sanctions. In the brief, Clayton's lawyer said to the court, petitioner wanting to be pregnant and being pregnant are two different things. Yes, it is. Despite her repeated assertions, positive HCG tests, notice he says HCG, the chemical that's there to make the positive pregnancy tests. HCG, not HPT. Get your acronyms correct. Tests are not verifiable medical evidence of pregnancy. Parenthetically, per the Office on Women's Health, a blood test, which petitioner ostensibly never underwent, is the best way for a doctor to confirm pregnancy. Got that? Couple of key points here. First, Clayton's lawyer told the court positive HCG tests, which is what HPTs are. No, they are not. Because you can have an HCG test that is a blood test. Like, it's going to tell you on your lab work, this is what your HCG levels are. Quit mansplaining stuff that you know nothing about. He said they are not verifiable medical evidence of pregnancy. Again, it's not clear why Clayton claims that every home pregnancy test sold in America is somehow meaningless. But for the purpose of this discussion, let's ignore that point. You keep saying HPT and HCG. They are not the same thing. They are two different things, Gringas. Get that? You got that? Second, Clayton's lawyer also told the court the best way for a doctor to confirm pregnancy is with a blood test. Okay, fine. And of course, Clayton's lawyer asked for sanctions against Laura because he claims she never underwent any blood tests. Okay. As of January 25th, he said she has not gone and gotten any blood tests done. Okay? January 25th, 2024. All right, let's move. Can you guess where this is going? Yep. On October 16th, 2023, Laura had a blood test done at a lab. Want to guess what the results showed? Pregnant. But don't take my word for it. The report can be viewed right here. Does this conclusively prove Laura is telling the truth and Clayton is lying? Of course not. That is something the judge will decide for us. But make no mistake, if anyone tells you there are no medical records supporting Laura's pregnancy, that person is lying to you. And if anyone tells you the only proof Laura had was a take-home P-type HPT pregnancy test, that person is lying to you. Update 4424. A new egg Twitter account, clearly a troll, just made a comment that actually seemed to raise a valid point. The guy looked at Laura's test posted above and noted something. The HCG level was 102. This is high enough to count as positive for pregnancy. But my troll friend said it was fishy. Why is this important? Per Professor Google, the detection of HCG is used to confirm your pregnancy after you conceive. When the sperm fertilizes the egg, your developing placenta begins to produce and release HCG. Now, I am no expert, but apparently HCG levels change a lot during pregnancy. Yes, this is why you shouldn't have been trying to mansplain things. They start very low and get higher during the pregnancy. A lot higher per this chart at the start of a pregnancy. HCG levels can range from 0 to 750, and as things progress, the levels go all the way up to a huge number like 210,000, even higher for twins. All else being equal, that suggests a test showing HCG levels of 110 several months into Laura's pregnancy raises a big red flag. Yep. My troll friend, now blocked, sorry bro, seemed to think that this absolutely sinks Laura's case. I mean, if the levels in the 5th month are only 102, and they should have been 210,000 or more if twins, yeah, that kind of looks bad for Laura, right? This man. Oh my God, this man gives me a headache. And Gringas says, I don't agree for 2 reasons. Of course not. Okay, so here is the lab test. Okay. So it says this was in Scottsdale from October 16th, 2023. Also, when did this get turned over? Did this get turned over recently? Because if it did, if she didn't turn this over, or this wasn't found out until after the January 2023 date, when Greg said there's been no lab tests, then as of that date, to his knowledge, there was no blood tests that had been provided or proven. She had never mentioned she had had one, or that she hasn't proven that she went and had one. So, she went to Sonora Quest Laboratories, and it says Owens, and her date of birth and her age, and female. It says chemistry. HCG quantitative test, 102. They labeled it as an H. And then it says, the ranges, a non-ovulating female, non-pregnant post-menopausal female, and then if it was a male. And then it was performed, and so it says values listed above may not include all results considered abnormal for this patient. But you know what it does not say? It does not say that this equals pregnancy. I am interested in seeing, I think I'm going to go back and look at my daughter's first lab test and then look at it closer to the end if they have the HCG in there, to compare the differences and at what points. I think I'm going to add that, and I'll show you. She was pregnant with one, and I know she's not everybody, but at least it would give us a good idea at jumping HCG levels in the same time period that Owens is claiming it. So the way they do it and the numbers and everything is in the same time frame, whereas if I found something from mine, what medical stuff was out there when I had babies as opposed to now, there may be some differences. They may have updated things, but this is going to be like around the same time period. So we will look at that. All right. First, the same page linked above says this: falling HCG levels may show a pregnancy loss or miscarriage. Okay, since Laura claims she had a miscarriage at some point after this test was done, the low HCG levels on this test may or may not be explained by the event. If anything, the levels may be completely consistent with Laura's story. She got pregnant, something went wrong, she had a miscarriage. I don't have the scientific knowledge to know what a woman's HCG levels should be shortly before a non-viable pregnancy ends, but it sure seems likely they would drop, maybe all the way down to 0. But here is the second thing, and it is the key point that everyone seems to be missing. I don't care about the HCG numbers in the 5th month. That issue is not relevant here. Why not? How could that possibly not matter? Here's why. The HCG number in the 5th month does not matter because it does not matter if Laura was or was not ever pregnant. Read that again. So this case has nothing to do with Laura being pregnant or not. Okay. I would like you to explain why she kept lying if she was not pregnant. That's why it matters. Is because even if she had been pregnant and lost the babies, and she could prove that, would have been like, okay, you know what? She was telling the truth. The fact that she was pregnant doesn't mean they were Clayton's, but I think it matters a whole lot. Think about this and please try to understand. Laura is no longer pregnant. She admits this. According to her, the miscarriage happened at some point way back in November of 2023. Now in April 2024, she does not want the court to declare Clayton as the father because there is no baby for him to be the father of. So here, you're saying she took a blood test in October, which could have started the beginning of the miscarriage that she had about a month later. Okay? So then later on, when you argue that she miscarried in July, why did she go to the doctor for a blood test with positive HCG if she was no longer pregnant? What that shows is that once again, she was not pregnant but still has positive HCG. She needs to find out what is medically wrong with her and why that HCG keeps coming back positive. There is something going on. Maybe it is her polycystic ovarian syndrome. Maybe there's something with endometriosis, cysts on her ovaries, something. And if there is something wrong that's causing this, she needs to figure out what that is. And as much as she wants it to be a baby, again and again and again, it hasn't been. And I'm sorry that she's not getting that baby that she so desperately wants. And to have that family and to have her soulmate. But that is not any of these other guys' fault. It's not even Laura's fault as far as the pregnancy goes. It is her fault that men don't want to be with her. But if she wants to be a mother and can't be, that's sad. And we can feel for her in that way. But it does not give you the right to do this. Because she would have all our sympathy. And we would all be on the same team and like, you know what? We're so sorry this keeps happening to you, Laura. Like, there are plenty of women that can't get pregnant, that should be allowed to get pregnant. There are plenty of people that miscarriage, that have their baby and have to bury them. And it's nobody's fault. We could have been there and had Laura's back on that and feel for her. But where she's screwed up is that she has just spit on everybody who has gone through that. And making her seem like she is a bigger victim than anybody else who has actually gone through this. It's not okay. It's ridiculous. And it pisses me off. Gringas says, because of the strange situation where Laura is no longer pregnant and is not asking the court to say Clayton was or was not the dad, it literally makes no legal difference whether Laura was ever actually pregnant in the first place. Of course, Clayton says she lied about the whole thing from the start, and that twist is what changes the situation drastically. Clayton claims is being made to support his request for sanctions and to support his request for finding of non-paternity. So now we need to ask, how can he get sanctions? What does he need to prove? To get sanctions, Clayton does not have to prove that Laura was ever pregnant. Put another way to avoid sanctions, Laura does not need to conclusively prove she was ever pregnant. She needs to prove she hadn't been lying this whole time. To get sanctions, Clayton will have to prove something different. That he had no basis to even think she was pregnant when the case was first filed. That is totally and completely different than Laura saying she was or wasn't pregnant months later. We are focused on what she believed on August 1st of 2023. Not whether that belief was still correct months down the road. People bring cases which end up failing because they are initially believed later and it turns out to be incorrect. But that's not what this is. That's not what this is at all. You say November. You also say July. Which, guess what? She filed in August? and she miscarried in July. July comes before August. So, like, where's your excuse there? The only thing that matters for the purpose of sanctions is whether the person knew their claim was groundless at the time it was brought. And that is a very high hurdle to clear. Well, with you as her lawyer, I don't think it'll be that hard. Because you don't know how to shut your mouth any more than your client does. Obviously, if a person believes they're pregnant on January 1st and they file a paternity action that day, but they have a miscarriage a month later, the court can sanction the woman for bringing a groundless case because the case was not groundless at the time it was filed. Same thing here. Nowhere near the same. Because in that scenario, the person didn't lie. That's the difference. Lie for months. Sit here and slander and defame a person. That's what makes this case different. And that she's done it to man after man after man. To repeat, the standard that matters and the standard the court will be asked to decide is not whether Laura was actually pregnant. I could stipulate she never was pregnant and we can still win. No, you can't. Here, for purpose of what Clayton is seeking, the correct legal standard is, did Laura have any reasonable basis to think she might be pregnant when the case was first filed on August 1st, 2023? That's it. That's the entire case. HCG levels month later? Not even the slightest bit relevant? And if you don't believe that, take more time and think about it. You will eventually see the light. I'm not going in that direction. I am actually going the other direction. So I don't think we're going to see the same lights. Like if you did a U-turn, like we might see the same light. But I am not doing a U-turn to go see the light that you're seeing. If Laura was never pregnant, but she had good faith reason to think she was, Clayton will lose his request for sanctions. For the umpteenth time, that is what will happen, even if Laura was never actually pregnant. I don't think what Clayton is fully after is sanctions. Would he like them? Yes. But what Clayton wants is an admission of guilt, admission that she was lying, and an apology maybe. Own up for her misdoings. Maybe promise not ever to do it again. And maybe the judge to give her a harsh talking to. That if there is ever a case like that again, it will likely mean jail time. But we'll see what actually happens. While I was finishing making this video, I thought Gringas was done blogging. I mean, he should have been. Like, I thought maybe he had learned to keep his mouth shut, but obviously not. Here we are again. So this last minute edition, what does justice for Clayton look like? Let me tell you. On April 16th, 2024. If you are following the Owens v. Echard case, you've probably seen a lot of folks talking about they want to see justice for Clayton. There's a Justice for Clayton Twitter account. There's a Justice for Clayton GoFundMe page. And I'm guessing Justice for Clayton t-shirts are next. Idea? JF condoms? Seriously? Like, oh my God, you're such an immature little boy. But what exactly does justice for Clayton look like? At the end of the day, all that happened here, from a legal perspective, is Laura hooked up with a guy, Clayton, who she thought was interested in her. Sadly, it turned out the feelings were not mutual. Sucks, but that's life. Yeah, Explain that to your client, please. That sometimes feelings aren't mutual. It sucks, but suck it up. It's life. Move on to the next one. Tell her there's plenty of fish in the sea. She doesn't need to do this. She doesn't need to give dating contracts. Laura claimed she got pregnant, and she did exactly what you would expect. She tried to talk to Clayton about the situation. Yes, I know some people think she didn't handle it very well. That's fair, and I'm not judging your harsh opinions of Laura. Of course, maybe you'd have a different view if you walked a mile in her shoes, as the saying goes. But here's the thing. This is a very strange twist of fate. But I have walked a mile in Clayton's shoes. Literally. When I was in my mid-20s, I hooked up with a girl on spring break. Days later, she called and said those two words you just don't want to hear in that situation. I'm pregnant. Just like that, my initial response was, wait a second. We only hooked up once, and that was like 6 days ago. How can you possibly know you're pregnant that soon? I feel like you're exaggerating here. Because 6 days after? No. No, that's too soon. Way too soon. Like, pregnancy tests have gotten better, but you're looking at least 2.5 to 3 weeks that you can find out. We're not quite at the 1 week or days mark yet in technology. I mean, eventually we might be there. I mean, there may be something like in the far future. I don't think it's like so close to happening, but there might be a point where you can find out like the next day or that same day. It was like, oh crap. Maybe it's like on our watches or something, and it goes off on our little Apple Watch 9000. It says, your egg has been fertilized. And then we're like, oh shit, time for plan B. Why didn't I take that birth control? I missed that one night. I wish that condom wouldn't have broke. But we're not there yet. Let's continue on and hear his story of how him and Clayton are just one and the same. It sounded impossible, but she promised me it's possible. Unlike Clayton, my response was very different. I told this young lady, first and foremost, the decision about what she was going to do was entirely up to her. I barely knew her. But I explained if I was the father, I would absolutely do the right thing and support her in any way necessary. As a man, even a young one, I just couldn't imagine turning my back on my own child, no matter what the circumstance were. Who would do that? It's not the child's fault that he or she came into this world unexpectedly. It's not. And you're absolutely right. If a man finds out that he is going to be the father of some babies, and he knows that there is a possibility that he impregnated somebody, he should definitely not turn his back on him. I do agree with that. But the thing here is, Clayton never believed she was pregnant. Because you can't get pregnant orally. So the girl decided to keep the baby. 9 months later, she called again and asked me to send a picture of my earlobe. To my shock and surprise, apparently there is 2 types of earlobes, attached and non-attached. This is apparently a reliable way of determining paternity. If the child has an attached earlobe and the mom does not, that means the father must have the same type as a kid, because genetics. No idea if it's true, but Google seems to think it's 100% accurate. Because everything you read on the internet is true, right? Wrong. Okay, so I'm going to kind of tell you a little funny story here. uh, Megan Fox last night said that people don't do, who uses earlobes to determine paternity. But what's funny is that my kid's dad, they have some strong genetics. And there's this little, like, it sounds so weird and wonky. They have this little bump that is on the ear. All the males have it from generations to generations. Like, there's not one single male that's been born that does not have this bump on the ear. It's very small, like, you really don't even notice it unless you're actually looking for it. But I had his stepmother tell me that, well, we'll just see if they have that bump on the ear. And I was like, what? So it's funny because that was something. And so now it's funny because now any babies, period, but definitely the boys, we see if they have that bump. There are a couple of girls that do have it. My daughter is actually one, and then her aunt has it. And then my grandson, who was just born 5 months ago, he's a boy, obviously. And while he's only, like, he's less and less and less a part of that bloodline, first thing I did was look for that bump. And he has it. It is very strong. So, now, is that all we would need to say paternity? No, obviously not. Take tests and stuff like that, which we did do with the father just because. Just to say, hey, yeah, this is it. It was easy and simple. And all of that. But it is funny because it's not the attached and non-attached, but it is this bump, and that I was threatened by a stepmother who was like, if they don't have this bump, then we'll know that it's not actually his. And it's like, excuse me? You think I'm lying? And my son came out looking identical to his dad. There's like no denying that boy. But anyways, back to what Gringas was saying. This was 1996. Phones didn't have cameras. I probably mailed her a photo on film and had dropped it off at Walgreens. Sometime later, I got the call. You don't have the right kind of earlobes. You can't be the dad. Okay. In the year 2024, maybe I would have responded differently. But in 1996, I breathed a huge sigh of relief. I went off to law school in 97, thinking I had dodged a bullet. Little did I know, 10 years later, in 2006, that bullet would come back. As I was sitting in my office on the 20th floor of the office building in Phoenix, when the receptionist buzzed me, yeah, David, there's someone here with some papers for you. Papers? By this time I was a lawyer, and I was used to getting served with papers. That was hardly unusual, but not with my name listed as a respondent in the paternity case establishment. I later learned my spring break fling had some personal problems. I think she had ended up applying for public health benefits for her child. When that happens, the state of Arizona asks, hey, why should Arizona taxpayers have to pay for this kid? Where's the father? Let's find him and make him pay. So they asked the mom who was the dad, and my name was given. This resulted in an Arizona Attorney General filing a petition paternity action against me on behalf of the Department of Economic Security. Okay, so she said, you are the father, you could possibly be the father. And that is what happens. I had been on government assistance myself, and when I was on disability And I tried to apply for TANF, which is where you get some money. Um, but they said in order to do that, they said, do you have an open child support case? And I said, no. The father and I split the kids 50-50 is what I said at the time. And they said that they would have to open a child support case if I was going to receive TANF, because they aren't going to pay for something that somebody else should be contributing to the kids. So that does happen. And the Attorney General's office will open a child support case or petition a paternity so that the dad can help the mother out instead of the government. Make the person who's responsible for these kids do it before the government does, which I can understand. The allegations in the petition shocked me. David Gringas is the father of this poor, desperate child? What? Okay. David Gringas has abandoned his child? David Gringas has refused to pay any support for his child? It was harsh to see those words in a legal filing, especially since A, the mom told me I was not the father. B, no one from the AG's office contacted me about this before the case was filed in court. Isn't there any due diligence requirement? No, there's not. They just file it because they want you to pay money and not them. The state wants to keep their money, so they need your money to help with your child if it is yours. If it's not your child, then it doesn't matter. They will have to go after somebody else, or they will give her government benefits. The papers included a summons with a court date, so I showed up in court without a lawyer. The judge, who I knew from other cases, asked me, "So what do you know about this?" That seemed like a strange question, but little did I know, Arizona law actually allows people to voluntarily admit paternity even if they are not the biological parent of the child. It's kind of like adoption. Some people just want to be parents of a child, even if it's not yours. No. Usually that's not how it goes. Usually, if it could be one of two people or something, and one of them has maybe been around the child, loves the child, and is going to love that child, whether it's theirs or not by blood, they may be like, you know what? Yeah, I'm the biological parent. I'm going to take responsibility because this is my kid, whether it is or it isn't. In my mind, you can't tell me that it's not my kid. Or that, yeah, I am the biological father. You don't need a DNA test because you know that you're actually the father. But your mistake in the beginning was you took the ears thing. I know you were young, but really you're just okay, well, the ears say no. I would have been no, I'm going to want a paternity test to make sure. That's what the judge meant when he asked what I wanted to do. He was giving me the option of just saying, yeah, I'll be the parent of this kid, even if I'm not actually her father. I'm a generous person, but I couldn't see taking responsibility of a child that wasn't mine, so I told the judge we should just take a test and see what happens. The AG had no objection, so we did a test, and guess what? The earlobe thing was 100% right. I was not the dad. I don't think it was the earlobe test. I don't think that earlobe test is accurate. I'm going to try to perform that earlobe test on my grandson and my children, and I'll update you what the earlobe test said later. I was not the dad. At least for me, that was the end of that. Yeah, at least for you, it was the end of that. But there's an actual kid in your scenario. That's what the difference is. And she wasn't going out there blasting, David Gringas, the lawyer, he abandoned his child. He didn't want this. He didn't want that. She wasn't out there doing all that. So yours is nowhere near like Clayton's. But you know what? I have walked a mile in Owens' shoes. Because my first pregnancy, I ended up pregnant with a guy's baby. And this was a bad decision for that. I was young and dumb. And he was crazy, and he smoked a lot of weed, and like it just was not a good situation. But I told him this, and I had him go to the first appointment with me so that I could prove this. Prove that I was pregnant. And I had currently just gotten back together with the kid's dad, my kids that are living's dad. And he had always told me, if you have kids with somebody else, we're not going to be together. And I was like, oh crap, we were finally in a good spot. We were back together. And I had just found out that I was pregnant with another man's child. So I had to go tell him I was pregnant with somebody else's kid. He knew it wasn't his kid because we hadn't been doing that at that point in the recent relationship, because we had just gotten back together. The dates don't line up. And the kid's dad was there for me during this pregnancy like a man should be. That was the person that I married. Obviously, he's not that person anymore. But that's a story for another day. But it's a part of my miscarriage, so to say, story. Because I ended up losing the baby. And when I did, I told the biological father, hey, I lost her. I gave birth to her. We're going to have a funeral for her. All this. He hadn't been to a doctor's appointment since the first appointment. He accused me of lying about the baby dying. And that I was just trying to keep it away from him and let my kid's dad be the dad and just push him out of the picture. And I was like, okay, well, you can go see her headstone here. I'll send you the death certificate, all that. Here's a picture. Like, I sent him all that to prove. It was quite easy to prove that I was no longer pregnant and I had her and she had died. Just like it was very easy to prove when I was pregnant with her. That look. And if he wanted a paternity test to prove that it was actually his, if the kid had lived or something, I would have done that. But I've been in Laura's shoes, where the father wasn't exactly happy. He wasn't a great guy. But I didn't go doing this, file a lawsuit, after I'd already had the baby or wasn't pregnant, saying, oh, I want all his money. He wasn't worth anything anyways, but I've been there. It's not the same. And what your client is doing is despicable. So, yes. Exactly like Clayton. Maybe. I was wrongfully sued for paternity. The Attorney General's office allegations were 100% false. I did not abandon my child. I am not a heartless deadbeat dad. The Attorney General did not make those false allegations. They were told you were the dad, so they went after the dad. If they would have said John Smith, they would have gone to them. But the Attorney General didn't pull a name out of the hat and was like, oh, let's just go after this guy. We don't have him on our dockets. Let's see what we can get out of him. They didn't do that. They were given a name. That was your accuser. the mother of that child that ended up not being yours. But unlike Clayton, I didn't turn around and accuse the Attorney General's office of fraud. I didn't seek revenge. I didn't demand justice. Clayton isn't going after the Attorney General's office. He's after the truth, and he's calling Laura a fraud. You're the only one talking about the Attorney General's office. The AG's office made a good faith mistake. Yes, they did. Laura Owens has made a bad faith mistake. She did this on purpose. They relied on the best information available, and the information turned out to be wrong. Under the law, that does not mean I was automatically entitled to sanctions, which seems to be Clayton's attitude. No, that is not his attitude. The law never ever requires people to be 100% perfect when they file a case in court. All that is required is a good faith basis to think your claims are probably true. If you can clear that super low hurdle, no judge will ever sanction you because your claims later turned out to be wrong. Yeah, but that's not what's going on in this case. You seem to not know anything about this case. That's not a bad thing. In the old days when people had disputes, they'd challenge you to a duel with pistols on Main Street at high noon, 50 paces, turn and fire. That's how disputes were resolved. It was messy, loud, and probably not fair, but it was fast and cheap. Why are we talking about Billy the Kid? What are we doing? What does that have to do with anything? Today, we have a more civilized legal system to help people solve their disputes. We want to encourage people to come into court rather than using violence or other means to solve a dispute. And as a part of that, we know that sometimes people will bring claims that turn out to be wrong. Wrong? Or later to turn out to be different is way different than claims that turn out to be lies. That's why I'm so confused at the angry Justice for Clayton fans who explain most of us are primarily interested in how to make sure this does not happen to any more men. False accusations help none of us. Yeah, okay, that's true, but in the world of false allegations, a mistaken, even groundless allegation of paternity is one of the easiest, quickest, and cheapest to disprove. Obviously not. Because this has been none of any of those. So I understand why you're scratching your head, because that's what we think too. Her proving that she was actually pregnant should have been easy and quick. But yet, here we are, and it's still not been proven. It's like shooting someone with a Nerf dart. Any collateral damage is virtually zero. Seriously, I know because it happened to me. Okay, I'm glad you play with Nerf darts. Oh my God, what is this guy, like, a word salad, as he said in this first blog, word salad, because, like, is he on the toilet, or, like, after he showers, he just comes and shares his shower thoughts with us? Because that's what this seems like. Because it doesn't make sense. Make it make sense, somebody. Make it make sense, because this is painful. Let's assume for a second that Laura was never pregnant. Or maybe she was pregnant. And Clayton wasn't the father, or maybe Clayton was the father. But Laura unknowingly had very early miscarriage, which would explain a lot of the later events we've seen. In any of those situations, is it really that big of a deal? I just don't see it that way. The only person making it a big deal is you know who, and his legal team. Cough, cough. Once again, this is not a script. It is a big deal. It is not okay to just go around throwing accusations and lying on people. That's not okay. You wouldn't want somebody doing this to you. If Clayton wanted justice, all he had to do was exactly what I did. Just take a very simple test and let the results speak for himself. He did take a test. He took 3. 3. If Laura was lying, there was never any chance that Clayton could ever fail that test. This should have been about 5 minutes of his time, and the total legal fees would have been $0, and Laura would have lost, and Clayton would have his justice, whatever that means. It wasn't that simple. Because, one, there are very few people that do DNA tests in utero with twins. There's like 1, maybe 2 in the entire country. Also, it is harder to do in ureter DNA tests, and they are way more expensive than waiting till the baby was born and getting a DNA test then. Those are easy, would have taken 5 minutes. It wouldn't have been $0 because it costs money, unless the court was going to cover the cost, but most likely they wouldn't have. So yeah, and that would have been nice and easy, just like it was for you. But that has not been Clayton's story. This woman has dragged him through the mud. That's why I just don't understand the anti-Laura mob mentality. Personally, I think when this all comes out in court, people are going to realize they were completely wrong about Laura. Like, completely. You know, we've read a lot of filings with Laura. And so far, I'm not seeing that. I mean, you could prove me wrong, Gringas. And if you do prove me wrong, I will come back and say, you know what, Gringas was right. I don't see that happening, but, I mean, it's not impossible, right? But even if I'm wrong, and Laura has lied about everything, so freaking what? I personally have a judgment that proves beyond any doubt that Arizona Attorney General brought a false paternity claim against me, which took literally 5 minutes of my time and exactly $0 to disprove. It was over so fast, all I lost was maybe 1 hour of my time. Yeah, but that's not what happened in this case. There was a real baby. A baby you could just swab real quick, just like that. But there has been no proof of babies. In this case, you can't swab or do anything with somebody who's not pregnant and has no babies. So, yeah, so effing what? This case didn't take 5 minutes. It didn't cost $0. And it was not over fast. I got justice in the end, and I'm fine with how it turned out. That child is so lucky not to have you as a dad. So when I look at what Clayton is doing in this case, all I can do is shake my head and wonder, what on earth is this kid thinking? Yet we wonder the same thing with you. And here is Gringas' little motion that DNA test was excluded, David Gringas as the biological father of the paternity, blah, blah, blah. So that's his court filing from 2006. And this is the picture that shows up when it's commenting. I'm sorry it's blurry here because I tried to enlarge it. This is not what Gringas looks like now. Maybe way back when he first started becoming an attorney. But he needs to update this picture because this is not what this man looks like now. He is way older. We have another one. He says, on April 18th, 2024, What the hell is a vanishing twin? An anonymous person recently posted this comment on my blog. Many others have said similar things. I think it's important enough to warrant a direct response. I am probably a minority in that I am following this case, but not necessarily part of the Justice for Clayton crew. I don't think it's fair to make assumptions until now evidence is seen through. I admit all the evidence out there really supports Clayton's side. Okay? So you can agree why we all think what we think. Okay. I agree it's reasonable to assume she didn't think she was pregnant or even was early on. Heck, Clayton believed it enough to take a test. I'm sure if you really did nothing that was even at risk for getting someone pregnant, you wouldn't bat an eye. But here's where I think the difference is that makes everyone mad. She didn't just miscarry and then move on. She faked ultrasounds, which she admitted, and while she hasn't admitted to it, I think it's obviously that she faked an ongoing pregnancy while knowing she wasn't pregnant, i.e. showing up to court in November with the bump. Now, whether all that stuff is related enough to get her in trouble in court, I don't know. I'm not involved in the law enough. But I think that's at least the basis of everyone being so angry. That's a very good point. Whoever wrote this. Because that's kind of why a lot of us are mad, is the fact that she has lied. We don't know at what point she lied, but we know she lied. Obviously, the bump in November proved she was lying because you can't adjust a baby bump in reality. But Gringas says, okay, let's unpack this comment because it's something I have seen a lot of people speculating about. And the theory goes like this. Okay, please tell us what we are speculating about. Let's go through these. Number 1. Laura had like 5 to 6 positive pregnancy tests before she filed the paternity test against Clayton. Actually, I think it was 4 positive tests before the case was filed, and then many positive tests after. Correct. She took a bunch of P tests that are pregnancy tests, pregnancy P tests, and they showed up positive. And then she kept taking P tests. That shows us nothing. Why is she only taking P tests? Is that because any other test is going to show that she's not pregnant? And this is the only thing that she can rely on to always give her that positive. Even if, okay, so after that. Okay, that's actually pretty strong proof she was pregnant. No, it's not. Since we can't prove she faked any of these tests, we can probably give her the benefit of the doubt and assume that she was pregnant, at least at first. And keep in mind, the paternity case was filed on August 1st, 2023. Okay? We'll keep that in mind, that she's taken P tests. And we might be able to prove that she's faked some of these through medical records or photos that maybe she used in previous cases that she tried to use in this case. Brian Neumeister will help us figure that out with metadata. Number 2, even if Laura was pregnant on August 1st, she claims she later had a miscarriage, maybe even as late as 22 weeks into the pregnancy, but maybe sooner. At the late stage, if she miscarried a child or twins that were between 4 to 5 months along, there must have been an obviously dead babies. You can't have a dead 5-month-old fetus fall out without noticing. That would make no sense. It's David Gringas note. I agree 100%. Okay. Number 3. Yeah. Because you can't. You just can't. And there's death certificates. Number 3, Laura has failed to offer any proof of these dead 4 to 5-month-old fetuses, and yet she has never explained where the dead babies went. Therefore, she must be lying. Gotcha. Well, kinda, especially when she said she had pictures of it. Okay, for all you keyboard warriors out there who read some shit on Reddit, watched a few videos on YouTube, and now you think you know everything about pregnancy, let me break some hard truth for you. You're wrong. You don't know everything, and neither do I, by the way. Oh my God. Please mark this day down. April 18th, David Gringas admits that he doesn't know everything. Mark it on your calendars. We need to celebrate. This is why you hire experts, because average people may think they know it all, but the truth is you just don't. No, seriously, stop. You don't. I'm talking to you here. And in this case, you didn't catch this news. Clayton has hired 2 OBGYN experts. Oh, wow, 2 experts. He must be double winning. So much winning for big, strong Clayton. But Clayton has not shared anything about what these experts are going to say. Having litigated tons of cases with experts, I can tell you that's not normal. The rules require this disclosure, so I assume Clayton will be sharing that information soon. Okay. Well, when we see the filings or see them in trial, we will see the experts. But Owens also said, Keith said he had an expert that was going to testify on behalf of Owens. Are you still using that expert? And Keith did disclose it. So I'm sure it will be disclosed eventually. Because he's not just going to be like, oh, look what I have, because you can't do that. This isn't TV. This isn't a movie. We can get a bunch of OBGYN experts. We could probably get thousands, hundreds of thousands to come in and testify this stuff. But like I said, we'll wait and see for trial what's said and what's shown. But here's more news. Laura also hired an OBGYN expert. Just one. Sorry, not doing the twin expert thing. That's a noob move. Okay, that's a dig at Woodnick. Our expert is reviewing info, asking questions, and he hasn't produced his expert report yet. Obviously, that will be disclosed to Clayton's team as soon as we have it, probably next week. I don't like to rush these things. You have hired this expert to look at the information. That doesn't mean that your expert that you've hired to look at information is going to agree with Owens. But okay. You can hire a bunch of people. Doesn't mean they're going to agree. That doesn't mean that they're going to say what you want them to say. Good luck finding somebody who does. So while I can't tell you exactly what Laura's expert has concluded, I can share with you some information. It is absolutely possible that Laura could have been pregnant with twins, had an early miscarriage of one, continued to gain weight, and then ended the pregnancy with a SAB, the medical term for a miscarriage, all without ever passing a stillborn fetus. Yes, but she said she has pictures of 2 fetal sacs. Or her sister has these pictures now. But don't take Dr. Gringas' word. Don't call yourself a doctor. You're not a doctor. This is a real medical thing that happens. It even has a pretty intriguing name. Vanishing twin syndrome. My kid's dad had a vanishing twin. We joke that he ate his twin in utero. I don't know if that's actually true, that he ate his twin, but he was a twin. She miscarried his twin, because Jesus is probably like, we don't need two of you in the world. But yeah. At one point, she only had the kid's dad left. Vanishing twin syndrome, as the name depicts, is a condition in which one of a set of twins or multiple embryos dies in utero, disappears, or gets reabsorbed partially or entirely, with an outcome of spontaneous reduction of multi-fetus pregnancies to a singleton pregnancy, portraying the image of a vanishing twin. In simple words, the number of embryos conceived, as observed through ultrasonographic examination in early pregnancy, differs from the number of fetuses delivered. But she didn't have a sonogram, not a real one. She got one off of YouTube. If there was an ultrasound that showed she had 2 fetuses at one time, and now there was just one, and then there was none, that would prove her case. But she doesn't have that. This phenomenon occurs in multi-fetus pregnancies, commonly during the first trimester. Yes, that's why it was absorbed, it vanished. That's why the joke is he ate his twin, because it just disappeared. Twin loss can happen in the form of a miscarriage, which the mother is aware, or in the form of vaginal bleeding or spotting in the first trimester without any knowledge of the mother, as vaginal bleeding is instead a frequent obstetric complication during the first trimester of pregnancy, so that the twin loss may go unnoticed. Yes, it might. But when she goes to all these appointments that she claimed, Dr. McCool and Dr. Higley and then another doctor that does seizure stuff, it would have been noticed. That's how it got confirmed with my kid's dad's mom. She was pregnant with twins. She did bleed, so she did notice it. But when she went back to the doctor in the next set of ultrasounds, it showed she had lost one of the twins. This phenomenon can range from the disappearance of an early empty gestational sac to a sac that had developed a fetal pole to a fetus with documented heart activity. Still not explaining where the two fetal sacs came from. You're not explaining how she didn't know when she was seeing doctors and supposedly getting sonogram pictures that she has not produced. Explain those things to me, please. Without getting too graphic, and to be honest, this is something I hadn't even considered, it is medically possible for a woman to become pregnant with twins, have 2 babies develop inside of her womb, and then something goes wrong and one baby stops developing and dies, but the fetus is not discharged from the woman's body. The fetus/uterus is simply reabsorbed into the body. Okay, so how did she end up with 2 fetuses that her sister has a picture of? Be honest. Did you know such a thing was possible? Until a few days ago, I had no clue this was possible. To be honest with you, I kind of understood why people like Clayton's lawyer were jumping up and down saying, "Where's the baby? Where's the baby?" in the absence of any other medical explanation, and for people who are not doctors, this made a lot of sense. I have seen suggestions that Laura must be lying about miscarrying so late in term, because if that happened, she would have been legally required to file a death certificate for the babies. Again, sounds like a cool theory, but is it solid? No, it's not. She would have still had to file a death certificate, even if there was one baby that miscarried at that point. So maybe not 2 death certificates, but at least one. If one got absorbed and one did not, and the other one happened at that 20-week mark, there is a death certificate. So he says, everything changes when you understand it is entirely possible Laura was pregnant with twins and had a partially early miscarriage of one baby, remained pregnant with the other, and then a second miscarriage of a baby, followed by reabsorption rather than stillborn. Okay, so now both babies have absorbed into her system. Okay. All right. Why are there two fetal sacs? That she said. Your own client said, I took pictures of two fetal sacs and sent them to my sister, got a new phone, so now I don't have them anymore. By legal definition, Laura would not be required to file a death certificate in that case because no child was ever stillborn after 20 weeks. See ARS 3630114, defining fetal death to mean the cessation of life before the complete expulsion or extraction of an unborn child from the child's mother. A dead fetus that is reabsorbed into the mom's body doesn't count as a fetal death because the unborn child never left the mom's body. Yes, this all sounds seriously kind of creepy, but stay with me. In this case, and yes, you will still need to wait for trial to get the full final story, it is medically possible that Laura explained vanishing twin syndrome or something familiar. That would explain literally every detail of what happened to her. No, it wouldn't. Go look at the deposition transcript. For the love of God. Because you haven't answered all my questions. It would explain the positive pregnancy test at the start. It would explain the partial early miscarriage, followed by more positive tests, concluded with very low HCG test, which confirmed non-viable of the second fetus. It still would not be down at 102. So no. Followed by complete reabsorption rather than stillbirth. This explains her weight gain. It explains the not fake moon bump. It explains the numerous positive pregnancy tests followed by positive but unrealistically low HCG results. Explains the lack of fetal death certificates. Literally explains every single detail, all of it start to finish. But hey, screw the facts. What fun is the truth when a lie sells so much better? Breadsticks aren't free, and people want more drama, more scandals, more lies, rather than nasty, depressing stories about dead babies reabsorbing into the mom. Ew. So we keep selling lies. It's better that way. No. No, it's not. That's not what any of us are trying to do. And we can afford our damn breadsticks. And they aren't free. You're right. We gotta pay for them things. And yeah, that is a sad story. And it would suck if it was the truth. And why wouldn't we want to share that story? Because that story would be educational to people. It would have more people know about it. But yeah, we're just out here trying to sell things. So I agree. Screw the truth. Just keep blogging about what a liar Laura is, what a saint Clayton is, and what an immortal scumbag attorney I am for standing by Laura's side. Keep doing that, folks. No chance Laura will sue any of you into homeless oblivion when it's all done, because we know you all really tired darn hard to be honest and fair. Just not sure a jury will see it that way. Enough unpaid commentary for now. Remember what our friend Mark Twain said. It ain't what you don't know that gets you in trouble. It's what you know for sure that just ain't so. Yep, maybe so. It's the fact that you knew stuff and you ain't telling nobody. Nobody would blame Laura for not knowing about a vanishing twin if that's what happened to her. What we do blame her for is lying about something that didn't happen. But keep trying to spin the story. Can't wait to hear what your theory is next. And I will give y'all a better quote. Stay tuned. All right, that is where we are going to end, because right now we are all caught up on Gringas' blog posts. If there are more to come, we will obviously look at those and go over them. But today, our quote of the day is, knowledge and ego are directly related. The less knowledge, the greater the ego. Albert Einstein said that. And it kind of rings true. The greater the ego, the less knowledge. Because when you have a big ego, you think you know everything. But you actually don't know everything. You actually know less, and you're not even willing to listen to other people because you are all-knowing in your brain. So, get rid of your ego and gain more knowledge. I think this quote fits very well for attorney Gringas. And y'all have learned a little bit more about me and some of my stories, and they'll be thrown into some of these videos. If y'all have stories, I would love to hear those as well. But until the next video, hit that subscribe button, turn your notification bells on, hit that like button on your way out, and I will see you in the next video. Bye.